My name is Doug Miller. I'm an attorney and gift planner here at Ozark Christian College in Joplin, Missouri. Welcome to this webinar, Estate Planning Without Lawyers. Estate planning is a very important topic, but one that's easy to put off. I hope this webinar provides some useful information and encourages you to take action. If you have any questions or comments, please be free to send them to me. My contact information is on this slide and it'll be repeated later in the presentation. So please feel free to contact me directly. Before we start talking about estate planning, I think it's important that we look at some biblical principles about our possessions and about stewardship. Psalm 24:1 tells us the earth is the Lord's and everything in it, the world and all who live in it. This scripture tells us that God is the owner of all. He created it and he's the owner and we're merely in possession of his property. 1 Timothy 5:8 also says, if anyone does not provide for his relatives, especially his immediate family, he's denied the faith and is worse than an unbeliever. Obviously, God expects us to take care of those who are depending on us, our children, our minor children, our spouse. Luke 15, Jesus tells 3 parables. The first one about the lost sheep, where the shepherd leaves the 99 to go after the one that's lost. The lost coin, where the woman with 10 coins loses one and turns her house upside down until she finds it, and then she rejoices. And finally, the lost son, or the prodigal son, who squanders his inheritance, goes off to a foreign country, and finally comes to his senses and returns home where his father is waiting for him with open arms. This reminds us that the lost are very important to the Christ and that he expects us to do something about that. And finally, 1 Corinthians 13:3, if I give all I possess to the poor, surrender my body to the flames, but have not love, I gain nothing. Obviously, the most important commandments, to love God and to love other people. God expects us to use what he's entrusted to us, his property, to seek and save the lost and to show love to the whole world that's waiting. Now, before we begin, I have a question. Why are you watching a webinar entitled Estate Planning Without Lawyers, especially a webinar, Estate Planning Without Lawyers, taught by a lawyer? Well, I think I have a pretty good idea. I realize the reason that most people don't make a will or a trust or an estate plan is because they fear it's too complicated or it sounds too expensive, or to be honest, they don't like dealing with lawyers. I understand that. I don't like dealing with lawyers either. As someone said, 99% of the lawyers give the rest a bad name. So I understand. Next, I imagine you would expect the lawyer to tell you that you must hire a lawyer to do your estate plan, right? Okay, I said it. We are talking about your life savings. We are talking about caring for your loved ones after you're gone. Your entire life savings and the loved ones you care about and the causes that mean most to you. Why would you cut corners and try to save a few dollars when there's that much at stake? It is a valid question. With that said, it's true. I do discourage people from downloading a form from the internet or copying a trust form from a book. Why? Primarily because those forms are intended to comply with all 50 state laws and are kind of one size fits all. It's the same form whether you're single or married, have minor children or no children, you're older or younger. Does one size fit all? No, not really. Many of the online forms are not free. And for just a little bit more money, you could have an attorney draw up a plan that's specific for your state and for your situation. I've been practicing law for over 30 years. And during that time, I've seen people that have tried to write their own wills. Unfortunately, they often create more trouble and incur more expense than if they would have had an attorney draw up one in the first place. So before we talk about what you can do without a lawyer, I want to talk about a few situations where you really do need an attorney. The first is if you have minor children. If you have minor children and something happens to both parents, a legal guardian is going to need to be appointed. Who would you want to raise your children if you weren't here? Also, if your children are minor and you died, they are not old enough to hold the money. They're not able to manage the money or take care of their own expenses for them. So someone's also going to have to be appointed to manage their money until they're older. And in most states, you become an adult when you're 18, no longer a minor, no longer on your own. So if you don't make a estate plan, your child's going to receive their entire inheritance the day they turn 18 years of age. Now, many parents think that it'd be better if we waited until the child was a little older and wiser before we give them their money, like say 21 or 25. By that time, they've hopefully completed their school and they've had a job and they know the value of a dollar, and they'll be more able to manage their finances. So again, if you have minor children, I strongly encourage you that you have an attorney draw up a will and you nominate the guardians you want to take care of your children and their property until they reach that age. So meanwhile, while the adult is holding the money for the children, they can still use it to pay for the child's expenses. And then what's left over will be given to the child when they turn 21 or 25. Another situation where you should consider hiring an attorney to prepare your plan is if you have beneficiaries with special needs. So they are going to need someone to help them manage their money as well and make decisions for them. And also they may qualify for some government benefits and they'll need help for that. You also should talk to an attorney if you have what I'm calling a complicated family situation. Maybe you have a beneficiary with an addiction. Maybe you have a beneficiary that's a spender, or maybe you have conflict in your family that children don't get along or the heirs don't get along. Well, you'd be well advised to have an attorney help you because you can foresee those problems before they happen. Another situation would be is if you have a family business, and often in a family business, whether it be a farm or a small business, some of the children are involved in the business and some of them aren't. So how do you prepare a plan that's fair to all, those that are working in the business every day and those that aren't? Obviously, if you have a large estate, you probably have attorneys and accountants already, so you'd be well advised to have them prepare a plan for you because they know your situation. And if you have tax issues. So clearly, there are some people and there are some plans that really do require an attorney's help to do that. However, with all that said, there are some situations that you can make plans without an attorney, even without using a will or without using a trust. For example, if you simply want to leave everything to your adult children or your adult beneficiaries equally, that's pretty straightforward. Or you want to leave a gift to your church or to ministries you support. Again, they're not minor children, they can handle it. Those can be outright gifts. So there are many situations where you can make some plans without using an attorney, and that's what we're going to focus on. When we talk about planning our estate, I think it's helpful for us to define the word estate, not a word we use every day. Estate is simply everything that you own when you die. So it could be your real estate, and it could be life insurance and retirement accounts. All this is going to transfer upon your death. So I want to talk about 6 broad categories of property. First one, real estate. Obviously your home, maybe you have rental property or rental houses, maybe you own a farm, have some vacant lots or business property, commercial property. All those are considered real estate. How do we know who owns real estate? You have to look to the deed. The deed says who's named as the owners. It's going to have the sellers, the people from whom you bought it, and then your names. So it could be in my name individually, or my name in my spouse's name, or my name in my children's name. You have to look at the deed to know for sure. The second category, vehicles. And when we're talking vehicles, we're talking about cars, trucks, motorcycles, boats, trailers, RVs, mobile homes. All these different types of property have certificates of title issued by the state, by your state Department of Revenue. So how do we know who owns those vehicles? Again, you have to look at the certificate. Is it in your name only? Does it have other people on there as well? So the way we know who owns vehicles is looking at the title. Next, bank accounts. We're all familiar with checkings and savings accounts, money markets, and certificates of deposit. Who owns them? Again, who's on the account at the bank? In the old days, we had signature cards. Now it's like 10 pages of papers when you fill out an account. But that's who is considered to be the owner, who is listed on the account at the bank. A fourth type of property, calling just your investments. It could be stock, bonds, mutual funds. Who owns investments? Well, if there are stock certificates issued, who's printed on the stock certificate as the owner? If it's held through a brokerage account, how's that account titled at the brokerage? Is it in your name only? Again, husband and wife, other different ways of owning it. The fifth type of property, I'm lumping together life insurance and retirement accounts. Obviously, there's different types of life insurance, term or whole life. There's different types of retirement accounts, traditional IRAs, Roth IRAs, 401ks, 403bs, etc. The reason I lump these together is because when you take out life insurance or when you open a retirement account, they'll ask you, who do you want this to go to when you die? And so for retirement accounts, it's very important that you name your spouse as the primary beneficiary and your children or other beneficiaries as secondary to that. So again, you get to designate on those accounts where the money goes when you die. And final, the category I call stuff. It's furniture, tables, chairs, tools, jewelry, dishes, collections, hay in the barn. Doesn't really have a title, does it? But you can direct what happens to that because we don't need necessarily to change the title to those accounts. It's often who's in possession of them. And you might make a letter of instructions and say, I want my collection to go to this person or that person. So again, that's just a big catch-all of your things, your personal property. So why all this talk about how property is titled? Well, there's one very important reason. What happens to your property when you die depends on how it is titled. Let me say that again. What's going to happen to your property when you die depends on how it's titled, who is the owner of it. So do you know how your property is titled? Whose name is on the deed? Whose name is on the car title or the bank account? How property is titled determines what happens to it when you die. Okay. When someone comes in and says, Grandpa died, my question is, what was in his name only? Which brings me to the second point. Property that's titled in your name only when you die must go through probate. Why must property in your name only go through probate when you die? Because after you've died, you're no longer here to sign the deed, to sign the car title, to sign the check. If there's property in your name only when you die, someone's going to have to get a court order to get it out of your name. So think about it. The bank doesn't want to give your money to the wrong person, not the first person that shows up at the bank and says, I'll take the money to them. No. The license department will not take your word for it that Granny wanted you to have her car. So no, they're going to require a court order so that they make sure they get it to the right person. And that court's called probate. Now, what will probate do with the property that's in your name only when you die? Well, that depends on whether or not you have a will. If you have a will, the court will look at the will and give the property to the beneficiaries you've listed. Time for another important statement. Number 3, wills don't avoid probate. Wills tell probate what to do. Again, some people sign a will and think, great, I've avoided probate. No, it doesn't. What a will does is so the court knows what to do with property that's in your name only when you die. Next question. Well, what if I don't have a will? Well, if you don't have a will, I've got some good news and some bad news. The good news is you do have an estate plan, even though you've not written one. The bad news is your state legislator wrote it for you. So if you have no will, state law determines who receives the property title in your name only when you die. So everyone has an estate plan. State law determines what happens to your property. Does that make you feel better? Typically, state law gives the property to your nearest relatives. You think the state law gives any of your property to your friends or your church or ministries that you support? No. If you want to tithe and make a gift to your church when you die, you must make a plan and not rely on state law. So, as I've mentioned, property in your name only goes through probate when you die. So the secret to avoiding probate, don't have property in your name only when you die. Important point number 5, you can change the title to your property without an attorney. So I'm going to look at some different types of ownership and how you can make changes, again, even without an attorney's help. The first type of ownership is joint ownership. So We've talked about property in your name only, which is sole ownership. This is joint ownership or co-ownership. So you might think the way I can avoid probate is add all of my beneficiaries as co-owners to my property. While that might avoid probate, you have to understand you're giving up some control. What do I mean? If I added my children to my deed to my house as owners and I wanted to sell it, guess who I would have sign the deed? Obviously, I would have to sign it. My children would have to sign it and their spouses. So you've given up some control. Now it's no longer your property. You are now partial owner along with the others that you've added to it. What if you add your children as co-owners on your checking account? Who will have access to your funds? Obviously they could. So don't be surprised if they withdraw money from your account, because that's what you do when you make them as co-owners. Let's say you have 4 children and you add one of them to your account. When you die, who gets that account? Does it go to the 4 children or the one who's on the account? Remember, how your property's titled determines what happens to it when you die. That account will go to the one child that you've listed on there and not to the other 4. So that may not be what you intend at all, but realize by making joint owners that you're giving up some control, giving up some access, and it's going to go to those who are on the account only. And one more consideration about making beneficiaries co-owners of your property. I state it this way: their problems can become your problems. What do I mean? Imagine you add your 4 children to your house title, and then they go through a divorce, a bankruptcy, or a lawsuit. All of a sudden, your property becomes part of their legal case. In other words, their problems have become your problems. So while you can add beneficiaries as joint owners or co-owners of your property without an attorney, it comes with its own sets of risks and potential problems. But fortunately, there are better options available. Let's look at the next one, a living trust. Here's how a trust works. You create a trust document, and it's considered to be a separate entity from you as an individual. And then I transfer the ownership of my property from my name to my trust name so that legally I don't own it, my trust owns it. I've named myself as trustee or manager over the fund, so I still get to use the property as always. It's just legally not mine. I am just the trustee of it. And then you serve as your own trustee throughout your lifetime. But if you become incapacitated or when you die, you've named in the trust document a successor trustee to take over when you're unable. So if I'm still living but incompetent, then that person's going to take care of my property and take care of my expenses while I'm alive. And then when I die, the successor trustee is going to pay my bills and distribute the rest to the people I've designated in the trust document. So in that respect, a trust kind of acts like a will in that it determines what happens. You've put a plan for your distribution in the trust document itself. So the way the trust works is it takes it out of your name, you put it in the trust name, you still are in control over it, and you've appointed someone to distribute that property when you're no longer around, okay? So as you can imagine, there are lots of different types of trusts, and trusts can get rather complicated. So I really encourage you, if you want to set up a living trust, that you talk to an attorney about that. Another option would be to do transfer on death titling. It's a relatively new way of owning property. And you can put almost any type of property to be titled transfer on death. So let's say I wanted to give a certificate of deposit to Ozark Christian College when I die. I could go to the bank and tell them, please change the ownership of this account to Doug Miller, Doug Miller, transfer on death to OCC, or the initials TOD. So while I'm alive, I'm 100% owner. The college has no ownership, has zero interest in it. They don't need to sign anything. They don't need to do anything. They don't even need to know about it. Meanwhile, I can continue to use the property. I can give it away. I can add to it, or I could even change the title to transfer on death to someone else. They don't need to know about it. They have zero interest. But when I die, then automatically Ozark becomes 100% owner by law. So again, you can see this is a great alternative for someone who wants to keep the property during their lifetime, but transfer to death to someone else when they're dead and gone. So depending on your state law, I know some of you are from different states. Your state law may allow you to title almost any type of property, vehicles, bank accounts, investments, even real estate. Now, I say you're probably going to need an attorney to help you prepare a transfer on death deed for your real estate, but otherwise, you can change your bank account by talking to the bank. You can change your car titles to transfer on death to someone by talking to the state Department of Revenue. And you can talk to your broker at your investments about having your accounts transfer on death to someone. Again, zero interest until you're gone, and then it's 100% theirs. Some limitations, obviously, this would not work well for beneficiaries who are minor or have special needs. They wouldn't be able to handle it if you left it to your 6-year-old, your 8-year-old. But it's a great option if you have adult beneficiaries or you want to leave it to a church or a ministry outright. Okay, very convenient way. You still can you still are in control of it. It doesn't give any interest now. It's just that way. If it's that way when you die, then it only does it. It's without going through probate, without needing a lawyer. Number 4, life insurance. Most of us are familiar with life insurance. You take out a life insurance policy, you pay the premiums, and you also get to select who will be the beneficiary, who will receive the proceeds when you die. It's basically a contract that says, I'll pay the premiums. When I die, pay that person, pay these people, okay? Sometimes we forget life insurance is part of our estate, and yet many people have life insurance policies worth thousands or even millions of dollars. An important question, do you know who the beneficiaries are of your life insurance policy? There's only one way to know for sure, and that's to ask the life insurance company. Maybe you purchased a policy before you were married or before you had children. Do you want to change the beneficiaries? Maybe some of the beneficiaries you listed have passed away. If you want to change the beneficiaries, you don't need an attorney. You just need to contact the company and file a change of beneficiary form. Now, some people own life insurance that they no longer need. My wife and I purchased life insurance when our kids were young, and we were concerned about the family's financial well-being if something happened to one of us. But now that we're older, we're more financially secure, our children have grown up and left the home, you might find that you have more life insurance than you really need. If so, one idea would be to name your church or a ministry you support as beneficiary. Your kids may no longer be dependent on you financially, but would the church miss you if you weren't there? Would they miss your giving each week, each month if you weren't there? Absolutely. So one idea would be to include them as beneficiaries. There's also a special opportunity for planning with life insurance that offers a tax deduction. You can actually transfer not just the beneficiaries, but you can transfer the ownership of the life insurance to a ministry. You keep making the annual payments, annual premiums payments, and to the charity, and they will give you a tax deduction for the cost of the premiums that you pay. So if you've had life insurance a long time and you don't really need it, you can transfer the ownership to the ministry, make the premium payment each year. And again, we have people that are doing that for Ozark Christian College. They're paying the premium, which isn't much, but when they die, it will be multiplied many times over, the benefits, the face value of the life insurance. So again, you don't need an attorney to change the beneficiaries. You don't need an attorney to change the ownership of the policy so you can deduct the policy premiums that you're paying. Okay. Number 5, appreciated stock, real estate, securities, or investments. So another planning opportunity that doesn't require an attorney is if you own property that's appreciated or gone up in value. Imagine you purchased some stock for $10,000 and its value is now grown to $100,000. Well, the IRS considers that $90,000 gain as taxable income. And if you sell it, you'll pay a tax on the gain. Depending on your tax bracket, it could be 20% or more. A wiser plan that you can do without an attorney would be to transfer that appreciated property to a charity like your church or OCC. And when you give it to the church or the college, the charity can sell it for no tax, and they'll give you a tax deduction for the full $100,000 gift. So as you can see, if you have some investments that have increased in value, it's an opportunity to support your ministries and reduce taxes, and it doesn't require an attorney. Obviously, I encourage you to talk to your tax advisor or your financial planner about your specific situation anytime we're talking about taxes. but it is an opportunity to do something significant and change some value over to a charity. Number 6, retirement accounts. Many of us have accumulated a considerable amount of money in our retirement accounts. It might be, for some of us, our most valuable asset. Retirement accounts include traditional IRAs, Roth IRAs, 401ks, 403bs, and others. Most retirement accounts allow you to designate the beneficiary at your death. So when you take it out, they'll ask you, when you die, to whom do we give it to? Typically, you name your spouse as a primary and your children or someone else as secondary beneficiaries. There are different types of retirement accounts. So again, other than Roths, IRAs, most retirements are funded with pre-tax money and are not taxed until the money is withdrawn. So there's taxable income on the gain, whether you pull it out during your lifetime or your beneficiaries pull it out when you're gone. Either way, someone's going to pay tax on that. However, there is one way to avoid paying taxes on your traditional IRA. Name a charity like your church or OCC as a beneficiary of your IRA at death. You simply fill out a change of beneficiary form with the company and include your church or other ministry as beneficiaries when you die. Any money that you leave to your church or the college will pass directly tax-free. Does not go through probate. You do not need an attorney to do this. It will reduce or eliminate the tax that you have. So if you have an intention to help a charity like your church and you have an IRA, you've got a real planning opportunity here where you can use the IRA to make your charitable gift. My wife and I are leaving a portion of our 401k to Ozark Christian College when we die. We funded that money with pre-tax money. It grew tax-free, and everything we leave to the college will be tax-free. The money that would have gone to taxes, the 20%, we now are going to leave to the college tax-free. I think that's good stewardship. And again, you can do this just by filing a change of beneficiary form with the IRA custodian, and you don't need an attorney. No taxes, no probate, no lawyer, right? In addition to naming your church or ministry as a beneficiary when you die, there's another planning opportunity with charities during your lifetime. As you know, when you turn 72 years of age, the IRS makes you start taking required minimum distributions out of your traditional IRA. Why? Because they're concerned about your financial well-being and happiness? No, the IRS requires you to start withdrawing money at age 72 so they can get their hands on the taxes. However, if you're 70 and a half, you can reduce or eliminate your tax burden. Remember, I said if you want to save taxes, include a gift to charity. This is called a charitable IRA rollover. You can direct your IRA custodian to send up to $100,000 per year from your IRA to charities like your church or OCC. The IRA custodian does not send you the money. It sends it directly to the charity. Even though it goes to the charity and not to you, you get to count it as your required minimum distribution for the year. As I said, you can do this up to $100,000 per year from your IRA. It doesn't, again, will be no taxes, no probate, and no attorney required. Again, I encourage you to talk to your tax planner, your financial advisors about a charitable IRA rollover. Next, I want to talk about charitable gift annuities. What's a charitable gift annuity? A charitable gift annuity is where you give funds to a ministry like Ozark Christian College, and they agree to pay you a fixed rate of return for the rest of your life. The rate of return is based on your age, so the older you are, the higher the rate is. These plans typically work best for folks 70 years or older. The following chart here that we're showing shows the current rates for a one life annuity. So as you can see, they're paying 4, 5, 6, even 8% of a return each year. Ozark agrees to make fixed payments each year. I liken these to certificates of deposit, except when you die, what's left over will go to the charity instead of back to you. These fixed payments can help supplement other income, particularly during your retirement years. And you get a partial tax deduction when you make the gift. They return the principal to you tax-free, and you have this opportunity to make a significant gift to a charity. You don't need a lawyer, but again, we recommend you talk to your your tax planners about this. Ozarks arranged several of these types of charitable gift annuities. If you're nearing retirement age and would like to know how you can make a charitable gift and still receive income for life, please contact me. We can send you a free customized proposal. I want to talk just a moment about what we call legacy gifts. A legacy gift is a gift that you make to a church or a charity, a ministry in your will, trust, or beneficiary designation. Again, it could be a beneficiary designation through your life insurance. It could be a beneficiary designation through your retirement account. It could even be a charitable gift annuity. These legacy gifts take effect at your death, and they provide for the long-term financial needs of your church or favorite ministries or missionaries. Obviously, if more people made legacy gifts, those ministries would have the resources they need to carry out the Great Commission long into the future, even after you're gone. So when I talk about legacy gifts, I'm talking about gifts that you make that don't take effect until you die, but will have certainly benefit a charity for years to come. Ozark Christian College has had lots of legacy gifts throughout the years. People have left and included the college in their will, their trust, their life insurance, retirement accounts. These gifts have allowed us to offer more scholarships to students training for ministry, start new programs, and renovate our campus. So we've created a special group called the Ozark Legacy Society. It's easy to join. Just let us know that you've named the college as a beneficiary of your will, trust, life insurance, or any of these legacy gifts. As a Legacy Society member, you'll be invited to special gatherings. We will give you a discount for the bookstore. We will send you a desk clock. You'll be able to, again, come to gatherings, special events on campus where you'll meet other friends of the school. We celebrate your decision by including your name in our annual report. If you'd like to remain anonymous, we won't list your name, but your gift, your example can be an encouragement to others as well. You can visit occ.edu/legacy and see the online application and download a free estate planning guide. Research shows that 90% of people would consider adding a gift to charity or a ministry in their will. However, less than 10% actually do it. Why? The most common reason given is, I never thought about it. So thank you for considering the legacy gift in your estate plan so that we can train more students for Christian service. Again, thanks for joining this webinar. If you have any questions, please feel free to contact me. You can always reach me at the college. My contact information is available. If there's any way I can help you or answer any questions, please let me know. Thank you very much.